There has been a major update regarding the public charge rule, and if you are planning to apply for a green card, the timing of your application could matter. The federal government has announced that the 2022 public charge regulation will be rescinded, and a broader public charge standard is scheduled to take effect on September 18, 2026. If you are preparing to sponsor a family member or apply for adjustment of status, it is important to understand what this change may mean. Under the Immigration and Nationality Act, applicants for lawful permanent residence must demonstrate that they are not likely to become a public charge. In general terms, that means immigration officers evaluate whether a person is likely to become primarily dependent on government assistance before becoming eligible for benefits. For many years, officers evaluated public charge under a totality of the circumstances test. They looked at factors such as age, health, employment history, education, family size, and financial resources. In 2022, the standard was narrowed. Under that version, only certain cash assistance programs and long-term institutionalization at government expense were considered in public charge determinations. Programs like Medicaid, with some exceptions, SNAP, food stamps, and public housing were not counted under the 2022 rule. The government has now announced that it is rescinding the 2022 regulation and returning to a broader interpretation of public charge beginning September 18, 2026. What does this mean in practical terms? Starting September 18, 2026, immigration officers may have broader discretion to consider a wider range of means-tested public benefits as part of the overall public charge analysis. These may include programs such as Medicaid, SNAP, housing assistance, and other similar benefits, depending on the final regulatory language and guidance. It is important to understand that use of public benefits does not automatically result in denial. Public charge decisions are based on a totality of circumstances. Officers weigh positive and negative factors together. A person's education, employment prospects, family support, assets, and affidavit of support from a sponsor can all be considered. However, because the standard becomes broader after September 18th, more applicants may face detailed review if they or members of their household have relied on certain public benefits. A new version of the adjustment of status form is also expected, with additional questions related to financial circumstances and benefits use. Filing with the correct version of the form after the effective date will be essential. Some categories remain exempt from public charge determinations: refugees, asylees, VAWA, self-petitioners, U visa holders, T visa holders, and certain other humanitarian applicants are not subject to the public charge ground of inadmissibility. Many family-based and some employment-based applicants, however, may still be subject to review. Consider an example. Maria is applying for a green card through her U.S. citizen spouse. Her family has used Medicaid for their U.S.-born children and receives SNAP benefits. After September 18th, officers reviewing her case may consider those benefits as part of the total financial picture. However, they will also consider her sponsor's income, employment history, education, and any evidence showing financial stability or improvement. Another example involves a couple adjusting status while receiving housing assistance. If they file before September 18, 2026, their case will generally be reviewed under the current rule. If they file after that date, the broader standard may apply. Timing may therefore be important for some applicants. What should applicants consider right now? If you are eligible and your application is ready, filing before September 18th may allow your case to be adjudicated under the current standard. After that date, ensure you use the updated form edition and carefully review all financial disclosures. Do not stop essential medical care or necessary benefits without consulting a qualified immigration attorney. Abruptly withdrawing from programs can create hardship and may not always be required. Each situation is unique. If you anticipate public charge concerns, begin gathering documentation that demonstrates financial stability or future earning potential. This can include employment letters, pay stubs, tax returns, education credentials, proof of assets, and a strong Form I-864 affidavit of support from a qualified sponsor. Legal challenges to the new rule may occur, but until a court blocks it, the announced effective date remains September 18, 2026. The key takeaway is this: the public charge standard is becoming broader again, and applicants should review their timing, documentation, and eligibility carefully. Stay informed through official government announcements and consult licensed immigration counsel for advice specific to your circumstances. This overview is for general informational purposes and does not constitute legal advice. Always verify your situation with a qualified immigration attorney before making significant decisions.